everybody to another episode of Consilia on the Couch. On today's episode, we're going to be discussing surrogacy in the UK, and I'm very excited to have with us today Dr. Bianca Jackson. Dr. Bianca Jackson is a very well-esteemed barrister specialising in international family law, children law, as well as alternative families, including surrogacy, assisted reproduction, and transgender children and parents. So thank you very much for joining us today, Bianca.
Thank you so much for having me, Isabel. I'm delighted to be here.
Brilliant. So I thought we'll get straight in. And firstly, I want to discuss how the legal process for surrogacy works in the UK.
Yes, of course. I think the first thing to say is that surrogacy in the UK is meant to be altruistic. So we don't have the commercial surrogacy regimes they have in places like the US, where you have really a strong regulatory framework and a seamless process to finding a surrogate to the conception of the baby. So we really focus on people doing it to help others, essentially. Now, commercial surrogacy itself is an offence under the Surrogacy Arrangements Act 1985. However, it's really important for surrogates and for intended parents to know that even if they do engage in commercial surrogacy, they're not going to be guilty of an offence. And so really what it's focused on, that act, is preventing third parties from brokering surrogacy arrangements for pay. And that also extends, interestingly, to solicitors as well. So if a solicitor is brokering any sort of surrogacy arrangement between a surrogate and an intended parent, then they have to be very careful because they could fall foul of that litigation. So that is really the underlying ethos of surrogacy in this jurisdiction. Looking more at the legal side of it, so parents are defined under the Human Fertilization Embryology Act 2008 whenever surrogacy is used. Now, it doesn't matter if the surrogacy arrangement took place in the UK or if it took place abroad. Our definitions of parents remain. And those definitions, as I said, are set out in that act. Now, what that means is that those definitions apply until such time as intended parents obtain a parental order. So in this jurisdiction, the person who carries the child is always the child's mother. Now, that's an irrebuttable presumption. It doesn't matter if that person is genetically related to the child or not. That person is the legal mother. So you can immediately see the difficulties for that in terms of surrogacy, because when you enter into a surrogacy arrangement, it's with the clear purpose of the person who carries the child not to be the mother. You have the intended parents who either want to be the mother, or if there's no male involved, then fathers. And so really what that means is that there's going to need to be an order that really extinguishes the legal parenthood of that mother and bestows legal parenthood on the intended parents. And likewise, if surrogate mother is married or civilly partnered, whether that's to a man or to a woman, the man would automatically be the father of the child who was born via surrogacy, and the woman would be the second parent, because we don't have two mothers in our jurisdiction, just mother, father, second parent. And so in order to extinguish the legal parenthood of those parties, intended parents have to apply for a parental order. And a parental order is like an adoption order in many ways. And they're really the only two orders of that type that Mrs. Justice Tice has referred to as transformative orders. So essentially what they do is they extinguish the legal parenthood of the surrogate mother, as well as her parental responsibility, and the legal parenthood and parental responsibility of her husband, wife, or civil partner, if she has one, and bestows legal parenthood on the intended parent or parents. Now, I think what's the most confusing thing for lay clients, and indeed for some legal professionals as well, is that, as I already mentioned, our legal definitions of parenthood apply regardless of whether the surrogacy took place in this jurisdiction or another jurisdiction. And so it doesn't matter if you did your surrogacy arrangement in a jurisdiction where the intended parents are listed as the parents on the birth certificate, you still need to apply for a parental order when you get back. There's no international convention that recognizes surrogacy arrangements completed in other jurisdictions. And I think that can be, as I said, incredibly confusing for intended parents, because if you go to a jurisdiction, let's say like California, and you have a child and your name is on the birth certificate, I mean, that seems as though there shouldn't be any other steps necessary. But obviously, when you return to this jurisdiction, if you want to have legal parenthood and parental responsibility for your own child, you will likely have to apply for a parental order to ensure that you have that. So that's necessary, as I said, regardless of whether you do your surrogacy arrangement in the UK or you do your surrogacy arrangement abroad. But fundamentally, what you're aiming to do is to ensure that you have legal parenthood and parental responsibility for your child, because that obviously has a myriad of different implications, everything from inheritance to being able to make day-to-day decisions if you don't have, having parental responsibility for the child and so on.
Brilliant. So that's, I mean, you've touched on obviously the commercial side and the altruistic side here. I guess in the UK then, surrogacy arrangements typically work without those agencies as they have in America, the commercial agencies. So what is there anything over here such as non-profit or any agencies here that can help parents going through the process?
Yes, that's absolutely right. There are around, well, there used to be 5, but childlessness overcome through surrogacy has recently stopped assisting with surrogacy arrangements. So right now there's 4 nonprofit organizations that are exempt from the rules under the Surrogacy Arrangements Act 1985. So they're allowed to assist with arranging surrogacies with intended parents and surrogates without falling foul of the law. So there's Brilliant Beginnings, there's Surrogacy UK.
That support for parents going through the process. And I guess, you've touched on California a lot, and we know through the press and social media that it's really, really well established. And I guess for parents that are looking at international surrogacy, what would you say the pros and cons are of that?
Well, I think one of the huge pros for parents going abroad and why they do often go abroad is because of the availability of surrogates. So because we have an altruistic system, it means that we're relying really on the generosity of women who are willing to carry children for other people. And, sometimes you can find those people through organizations like Surrogacy UK and Brilliant Beginnings. Other times you have a family member or a friend that might be able to do that. But when you have a more established commercial surrogacy setup, as they do in somewhere like California, you have a lot more surrogates who are willing to step in. And that's not to say that they're doing it for commercial purposes. Most of the surrogates, indeed all of the surrogates I've spoken to, have been very clear that their first priority has been about helping someone else create a family. But obviously, given the inconvenience of pregnancy, loss of wages, and so on, you're going to get more people willing to do it if there is a financial compensation aspect as well. So I think that's a real attraction to going abroad because you have so many more surrogates available. Obviously, one of the detriments of going abroad is really the financial aspect. So going to somewhere like California or any of the states in America are going to be much, much more expensive than the altruistic system in the UK, which still requires intended parents to pay surrogates for reasonable expenses. So it's not the case that everything's free. But if you do a sort of a comparison, I think the latest figures are that in the UK, you're looking at around between 15 and 20,000 pounds all in, including the medical treatment and so on. Whereas you go to somewhere like California, you're looking at $120,000 and upwards. So there's a huge financial discrepancy. However, then there's also people who go abroad to jurisdictions where it's a lot cheaper. So there are countries where you're not going to be paying £120,000, you're going to be paying rates that are more comparable to the UK, but where you're still able to access a surrogate in a more commercialized way. So you don't have to, for example, go through one of the nonprofit organizations and so on.
And I know, I should have said this at the start, but me and Bianca gave me some training on surrogacy, and I know you touched on it before, where there has been issues where surrogacy is illegal in that country, where the parents have gone over to have the surrogacy. And I guess it's, what would you say kind of your risks almost to parents where that is the case, and they haven't been aware or they didn't know?
Yes, I mean, a lot of that comes out of intended parents not necessarily doing due diligence beforehand. So, not speaking to lawyers both in this jurisdiction and in the jurisdiction where the surrogacy is going to take place. And sometimes, unfortunately, there are clinics who are exploiting essentially intended parents in their desire to have a child and maybe aren't as clear with them about the laws in the country where the surrogacy is taking place, or taking advantage of the surrogacy arrangement once it's already started. So you might be aware there's been a recent spate of cases in Northern Cyprus, one of which I was involved in, where, at least in my case, the intended parent specified where he wanted the surrogacy to take place, and during the course of the pregnancy was told by the clinic that no, the birth wasn't going to take place in the country that he'd identified. It was going to take place in a country where surrogacy was illegal. So you have really two strands. You have the ignorance of intended parents, and also the ability of clinics to make decisions like that, because intended parents are really stuck between a rock and a hard place, because what legal redress do they have in those circumstances? So there can be a lot of different issues arising out of that. And in terms of illegality in countries, it's obviously incredibly stressful to be in circumstances where you're having a child in a jurisdiction that you find out that you're not legally allowed to engage in surrogacy. And it can involve a lot of subterfuge. It can involve being concerned about the authorities in that jurisdiction stepping in and taking the baby. And then ultimately, when you get back here, the concern is that the court, even if you apply for a parental order, might take the view that they shouldn't provide it or grant it because your actions have fallen foul of public policy. So you've gone to a jurisdiction where you've engaged in something that's illegal. Now, in my case, and indeed in the previous cases that have a similar factual matrix, the court has ultimately made the parental order because fundamentally the court's primary concern is the child's welfare. And so it's almost always going to be in the child's best interest for a parental order to be made, recognizing the intended parents as the legal parents. And so even in those situations where there's been illegality, the court, albeit with some resistance, has made those orders for the long-term, medium-term, and short-term welfare of the child in this jurisdiction. But it's just so important. And indeed, the courts have said time and time again in judgments how important it is that intended parents get legal advice, not only in this country, but in the country where the child is going to be born. And that's not just family law advice, that's also immigration advice, because there's plenty of children in surrogacy arrangements who the intended parents went to another jurisdiction to have the child and then face difficulties returning to this jurisdiction with the child, and can end up being stuck months and months and months in a country where they themselves have no ties, and they haven't thought ahead that that might be an option.
Yeah, I think, like, as you said, it's due diligence, isn't it? And making sure you've got all that advice before going through the process. And I guess, on the flip side, what are the pros and cons of doing it domestically here in the UK?
Yes, well, I think domestically is ideal in the sense that you can have a relationship with your surrogate if you want it, but you can also have it information more freely. You can be more engaged or not in the medical processes. You can have a lot more just engagement more generally with how the surrogate is doing. Because it's an altruistic process, you would hope there's going to be no exploitation involved. Usually there isn't, though there have been some cases where there has been exploitation, even in the UK, of vulnerable surrogates, and indeed sometimes vulnerable intended parents. But for the most part, especially if you're going through one of the nonprofit organizations, you have that structure in place that will assist the intended parents and indeed the surrogate knowing what their rights and responsibilities are. And a lot of people like that aspect of it, like the security and like the ability to have the surrogate to be involved with the surrogate in the process and even afterwards.
Yeah, I get that. I can imagine, it's almost like creating a unit through the process together. And I guess, what's been your experience? Obviously, you've been doing this a long time now. You're a specialist in the area. Has it been positive, or what would you say the key things that have stood out to you?
Yes, I mean, what stood out to me most of all is the ability of the court to take the statutes and really read them in such a way that ultimately it's serving the best interests of the child. So what I haven't touched upon really is the criteria of the parental order. So there's a number of criteria under Section 54 of the Human Fertilization Embryology Act 2008. And those are the criteria that you have to meet in order to obtain a parental order. And so those things very much range from the time period in which you have to make that application for a parental order to obtaining the consent of the surrogate and her husband or wife or civil partner if she has one. So a whole myriad of things that intended parents have to fulfill in order to obtain that parental order. However, there's been circumstances, and there's often circumstances, where they're unable to fulfill that criteria for whatever reason. So just to give you by way of an example, I had a case where I had a client who was going through a divorce. He had twin children via surrogacy who were, I think, about 4 or 5. And it was only in the process of going through the breakdown of the marriage that he realized that he and his wife or ex-wife did not necessarily have legal parenthood or parental responsibility for their children. So a lot of people, especially, 10 years ago, were living in ignorance, and these things would only come up in the course of relationship breakdown or something else going wrong. And I mean, I think the eldest children I've ever had from intended parents applying for parental responsibility for a parental order, sorry, were, 15, 16. And there is a case where intended parents got a parental order subsequent to the child becoming an adult. So there's been many cases where obviously that's not going to fall into the 6-month window when you're supposed to apply for a parental order after the child is born. And what's really, I think, exciting about this area of law is the way the court has looked at the black letter law and then read it down in a way that's compliant with statutory interpretation to enable the parties to still make an application for a parental order, notwithstanding that on the black letter law, they don't seem to meet the criteria. So the courts looked at statutory interpretation both in a domestic way of reading down the statute, but also in a way of looking at it to ensure that it's compliant with the Human Rights Act as well, and the parties' Article 8 rights under the European Convention on Human Rights. And so that's been, I think, a really exciting and interesting way that the court has done that in order to meet the overall goal of ensuring that the child's best interests are secured and secured for the rest of their life. And so we've seen that not just with the 6-month period, but almost with every criteria under Section 54, the court has been able to read it down to allow that parental order to be made, except in respect of consent. Consent is a sacrosanct provision in the Human Fertilization Embryology Act 2008. If you don't have the consent of the surrogate and her partner, husband or wife, then that parental order is not going to be made.
Okay, and I guess, in respect of your experiences in your cases, is there any cases that you think, really outline how important it is to get advice from the get-go. Obviously, you've mentioned the international one. Is there any others that you'd want to share in respect of the overall picture of how surrogacy works and the importance of getting advice beforehand?
Well, I have to say that every case I have, because the cases generally come to me when there's already a problem.
Okay.
So, a lot of cases are very straightforward, especially domestic cases. So domestic surrogacy cases, you usually will have intended parents and surrogates who have gotten advice or have gone through one of the NGOs, and so they know what their rights and responsibilities are. They'll make that application. Unless there's a problem in a domestic surrogacy arrangement, then it's dealt with by magistrates. So it's very straightforward. So I don't tend to get a lot of domestic applications because parents usually represent themselves because they don't
Okay.
need an advocate. But so I tend to come in when either it's a complex domestic case or whether it's a high court case. Now, all international parental order applications go to the high court, not just the complicated ones, but I'd be dealing with both the more simple ones and the more complicated ones in the high court. And so those are really, in terms of cases that have stuck with me, I think all of the ones that I've done in the high court have really would have, the parents, well, for the most part, would have been better off getting advice at the outset.
Yeah.
Because they go in not knowing the criteria and then inevitably fall foul of the criteria. That's not all of my intended parents. A lot of them do go early on, but the ones where something has gone wrong, it's because they haven't gotten advice in the first instance. And I think that was very clear in the case that I touched on earlier, the Northern Cyprus case, where the client really went in blindly, not knowing really that the different legal jurisdictions and the implications that it might have for this jurisdiction. I had another set of clients who also went to a jurisdiction where surrogacy, not only was surrogacy not legal, but same-sex relationships weren't legal, and they were in a same-sex relationship. And so they went into a jurisdiction essentially having to hide who they were and had to remain there for a longer period of time than they anticipated. And obviously, you're having to live then in a place that is not sympathetic or welcoming to your sexuality. And so you have the double stress of caring for a new baby or waiting birth of the new baby, but also concerned that, are you going to be outed, and some sort of legal difficulties are going to arise within that jurisdiction. So had they gotten advice in the first instance, they may have thought differently about where they engaged in their surrogacy arrangement.
Yeah, I think in a nutshell, then I think it's get the advice from the outset and go from there. But that's been really, really interesting, Bianca, refreshing for me as well, and to hear the snippets of your experience. I guess to say to the viewers, if you are thinking of going through the process, obviously reach out to us. Dr. Bianca Jackson, speak to her before, or if you need her in trouble as well. But that's been really brilliant, and thank you so much again for your time, Bianca, today.
Thank you so much for having me, Isabel. It's been a pleasure.
Take care. Bye, everybody.
Bye.